Across America, cities are using bogus blight designations to bypass protections for property rights. Using blight studies that cite things like old paint and stray cats, they take well-maintained homes and businesses and hand them over to private developers who will build new properties for wealthier people. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. Today we have with us IJ attorneys Bob Belden and Bobbi Taylor to discuss challenges to bogus blight in New Jersey and Missouri. This is Beyond the Brief. So Bob, tell us who IJ is representing in Brentwood, Missouri.
In Brentwood, we represent 3 small business owners and 1 property owner who have called a commercial neighborhood called the Manchester Corridor home for years. A couple of them have been there for a couple decades. Sisters Amy, Stanford, and Carolyn Wilson run Time for Dinner, which has been in the area since 2004. Bob Story runs Feathercraft Fly Fishing Store, which is like a world famous fly fishing shop. They're like 10 minutes away from the St. Louis airport, and people come from all around the world to get these like tiny handmade fly speck things. Bob's dad opened that store, and they've operated in the same location, I think, since 1989. And they leased the location from our other clients, the George brothers, Martin and Anthony, whose dad built this building with his bare hands and like originally ran his own small business in it, but then he started leasing it out to other entrepreneurs. And our last set of clients are Roxanne and Carter Meyer, who run this like really funky convergence body and dance. Like it's all kinds of body work. Roxanne runs dance classes, and Carter is a chiropractor. So like you can come in, dance until your back hurts, and then, Carter will serve you.
Sure.
Yeah. But they've all been in the neighborhood for years and years, and want to keep operating there.
And Bobbi, we have similar sort of small business owner clients in Perth Amboy, New Jersey. Can you tell us about them?
Sure. So our clients in Perth Amboy are Honey Mirzone and Louis Ramiro. So Honey owns a multifamily apartment building with her mom and her husband. It is home to 4 families. The interesting thing about the building is that none of the tenants have cars, and they can all walk to work and walk to public transportation. So they rely on the location of the property for proximity to, their livelihood. Honey and her mother bought the building after Honey left her ex-husband. She had children. She had no source of income. And since then, that building has really become a lifeline for her family. And it's become kind of a symbol of Honey's legacy that she wants to leave for her children. Louis, his father, fled communist Cuba when he was younger. I think Louis was about 8 or 9 years old. After his father owned a fruit stand, and the government, little by little, took portions of it until it became no longer profitable to operate. So they came to America looking for something better. Louis's father opened a tire and auto repair shop. That's where Louis learned the trade. Years later, when his cousin decided to sell his own tire and auto repair shop, Louis bought it. It's been in Perth Amboy for decades, and he owns the business and the property. And like our clients in Brentwood, Louis wants to stay. It's thriving. It's operational. The community knows it. And for Honey, not only do her tenants depend on the location of the property to get to their jobs, but it's a symbol for Honey of everything she's overcome. As a, once single mother struggling to make ends meet, this has really become, a symbol of how she's worked to build her own American dream.
I was about to say, these sets of clients both sound like kind of picture perfect examples of what we think of as the American dream. They kind of built themselves up from nothing. They've established these businesses. Of course, if nothing had gone wrong, they wouldn't be our clients, but something has in each of these cases. Bob, could you kind of start us off? What went wrong in Brentwood, Missouri?
Yeah, in Brentwood, these folks, our clients and dozens of other property owners in this same neighborhood, found out that in July 2023, the city of Brentwood, a small suburb of St. Louis, declared their neighborhood to be a blighted area. And that is, it has a lot of consequences, but the primary one is that it authorizes the use of eminent domain to take the properties in that area. So that's how we came to represent the folks in Brentwood.
And I assume something similar has happened in Perth Amboy.
Right. So like Missouri, eminent domain can be used in New Jersey to clean up blight. And it's a much smaller area. It's really just 2 properties. But when the city of Perth Amboy decided that they wanted to include these properties in their redevelopment, all of the sudden they were blighted.
Bobbi, you just mentioned blight. Bob, you've talked a little bit about blight. When I think of blight, I kind of think of, a city on retreat. There's graffiti on the walls. There's boarded up windows. There's vacant businesses. There's rampant crime. It doesn't sound like that's what's going on in either of these neighborhoods. So what is really going on?
Yeah, no, that's totally right. The place where our Brentwood clients are located, totally unremarkable commercial neighborhood. The city of Brentwood, as evidence of blight, cited things like cracks in pavement or peeling paint on buildings. And what's actually going on is that Missouri law imposes a number of obstacles, and one being cities cannot use eminent domain to take people's property for economic development alone, right? So what the city has done is identify a bunch of normal-looking properties and said, well, these are not normal properties. They're actually blighted, and we're not taking them because we want to give them to a private developer, which we are going to.
Of course.
We're actually taking them because they're in such a bad state that they are a public problem, and they need to be eliminated. So that blight designation opens up access to the eminent domain power, which is otherwise restricted.
So you used the words economic development, which I think people who have been following IJ for a long time will kind of connect like eminent domain, economic development to the Kelo case from back in, I think, 2005. So can you explain a little bit kind of what happened in that case, and then how does this law in Missouri sort of connect to that case?
Yeah, so Kelo was a case about the federal Constitution, the Fifth Amendment, and specifically the public use provision of the Fifth Amendment. Basically says nobody's property can be taken, or it says your property can be taken for a public use, but you've got to be given just compensation. The case, Kelo, was about what does public use mean? Is it enough for a government to say, well, it would be good for everybody if, in that case, it was Pfizer, was going to be developing an area, if we could take this property from the individual property owners and give it to somebody else who might use it, in a roundabout way, we would say to pay higher taxes. They're going to do something more valuable. That would be good for everybody. The U.S. Supreme Court in Kelo held that the Fifth Amendment's public use provision is no bar to that kind of a taking. You can kind of speculate this other private property owner is going to use it better, and that's better for everybody. A bunch of states, people all over the country freaked out and said, you can't take my property for that. And a lot of states agreed. In the decade after Kelo, 47 states changed their laws to say that kind of taking is not allowed. The holdouts are Arkansas, Massachusetts, and New York, so be on the lookout there. But Missouri is one of the states that actually responded to Kelo and said, all right, we need to tighten up our eminent domain laws. And as a part of that, the Missouri legislature looked at its blight definition and certain statutes about designating areas to be blighted because they acknowledged sort of at the same time they were reining in eminent domain, governments are going to try to get around this restriction and find a way to take property from small business owners like our clients and give them to big developers.
So, Bobbi, what happened in New Jersey after Kelo? I know that IJ had sort of a bunch of eminent domain cases there. And so did they change their laws through the legislature or through kind of litigation, or what happened there?
So it was mostly through litigation, and it's kind of the same but a little bit different than what happened in Missouri. So the New Jersey state constitution actually calls the remediation of blight and the development of blighted areas a public use for purposes of eminent domain. So you can, in in New Jersey take private land for economic development, but only if it's blighted. So what we saw after Kelo and some of our early eminent domain work in New Jersey, like the Long Branch case, was this expansion of the definition of blight to include really anything that cities needed to say in order to take the land for economic development, even though the area was not blighted. In Long Branch, it was I think they cited something called diversity of ownership, which basically means that the homes were owned by different families. That can't be blight, because then every home in America
That would cover a lot
is blighted,
of territory.
and it should be a point of pride, really, to own your home as a family. In Perth Amboy, interestingly enough, they're not really saying that anything is wrong with these individual properties. They're citing things like, oh, there was trash outside, or someone saw a few stray cats behind the tire shop. Nowhere in the blight study does it say, these properties themselves have anything wrong with them.
So what's the sort of Pfizer equivalent in both of these towns? Like, what is Brentwood trying to build? What is Perth Amboy trying to build to sort of do this economic development?
So in Perth Amboy, we don't know, because Honey and Lewis's properties are not included in any development plan. So about a decade ago, the city acquired the vacant lots behind Honey and Lewis's property, and it sat vacant and accumulating garbage and weeds until about late 2023, early 2024, when they finally reached a contract with a developer out of Denver. That developer did not include Honey and Lewis's properties in their plans. But somewhere in late 2023, early 2024, I think someone at the city looked at the corner of Smith Street where these properties are located and said, hey, we might be able to do something with these too. The plan is for kind of a mixed-use development, warehouses, apartment buildings, retail, but I don't know what they want these two properties for, because the developer still has no plans for them. The city just wants them.
Well, and the other thing that kind of stands out to me with Perth Amboy is just the timeline of it. There was no complaint about blighted property. There were no issues with the neighborhood until a developer comes along and then wants to work with an adjacent piece of land. And then now suddenly there's this blight study. That alone on its face seems to me to suggest that this is kind of pretextual. What's been the public reaction in Perth Amboy?
Honey and Lewis have a lot of community support. Lewis's Tire Shop it's like I said, it's been around for decades, and it services a lot of the community. And, Lewis being an immigrant, the child of an immigrant, he has a big Hispanic customer base that rely on their ability to speak Spanish and their proximity to their homes. Mm-hmm. And Honey's tenants they've been residents of Perth Amboy for over a decade. 3 of them actually rented when Honey bought the property from the previous owner. Honestly, the community has showed up to support in the city council meetings. Many people spoke on behalf of Honey and Lewis. The city council just voted to blight the properties anyway.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
And is there something similar going on in Brentwood?
There is something, I think I'd say similar. Yeah, I think the development is a little more, sketched out. They have been working on this plan for several years in Brentwood. The idea right now is to replace our area in Brentwood is a little bit bigger, I think, than what we're dealing with in Perth Amboy. And I mentioned our 4 clients, they only account for 3 of the properties in the area that's been blighted in Brentwood. It's actually 75 different parcels.
75?
75
Wow.
parcels and 77 acres, right? So 75 properties in this town of 8,000 people that has a board of aldermen with 8 people, each of whom is separately elected in districts. So you're talking about 5 of those 8 aldermen can vote to blight an area in the city of Brentwood. So 5 of those aldermen could have won their elections with like 1,500 or 1,600 votes. And like now they have the power to make a blight designation that allows them to take property from 75 different people in the city. The development that is sketched out for those properties is a mega development. It's valued at like $440 million, but there are kind of 2 ways that this discussion could go. In reality, we do know that the city's hand-chosen developer for this project is actually on its way to bankruptcy. It's been sued by basically everybody under the sun that's done business with it, and it's been replaced by a sort of fledgling developer that's got no track record. What they wanted
Sounds like the right guy to pick for a $440 million job.
Really good idea to use eminent domain to promote that
totally.
plan.
Yeah, sounds like it's going to actually happen.
Sounds like it. If it does happen, what they have proposed to do is to line, what is now small businesses along a pretty busy street is going to be, different franchised businesses and in sort of bigger locations along that same street. And then one of the real treats of the trial that we had in this case was hearing the city made a lot of sort of post hoc arguments about flood risk in the area, trying to justify what it had done. And we learn, during the course of this case, and we show at trial, that the development plan shows the city putting like condominiums and apartments in a flood zone, like right by an area that's gonna fill up with water. And that's a part of the development. So it's mostly just like retail shops replacing current retail shops. They're just going to be bigger. And then you'll have housing in a potentially dangerous flood zone for some reason.
So both of you have talked about sort of city governments voting to blight an area, which is strange to me. Because it makes it seem, and perhaps this just kind of like shows the government's hand to some extent, but that's a subjective thing, right? There isn't this sort of, this is objectively blighted or objectively not blighted. It's we've decided to like tap it with the blight stick or not kind of thing. And so how is a blight designation supposed to work, and where exists this line between like this is legitimately blighted, it makes sense for a city to sort of clear this area and build something else or whatever, and where we are now of these are well maintained, totally normal properties that the city is just sort of like using this as an excuse to do whatever it wants.
Well, I think there are probably close cases. I would say, I haven't seen the properties in Perth. I'm guessing they're not, blighted. I don't think Brentwood is anywhere near a close case, but I think the way that these are supposed to work, the state is supposed to create some criteria, some sort of, objective criteria about the state or condition of the property that's going to be blighted. And then your municipality, your county, your government is supposed to marshal some evidence to show that this area meets the criteria that's been set up by the state. And then the courts are there as a sort of backstop to engage in a sort of evidentiary review, looking at what the city looked at, what determination it made, and trying to see if that statutory criteria has been met. I think it's supposed to work that way. And, I don't know that a legislature could write really specific property codes for you to identify blight, but creating criteria that are tied to things like whether there are dangerous conditions on a property, I think is a good start.
Could we get a little bit more specific, too, about the arguments for blight in our clients' cases? What's the smoking gun that Brentwood has that says, this is proof that these properties are all blighted?
And you can feel free to jump in on Brentwood if you want to, but I think one of the sort of most absurd claims, to give you a little background, the city relied on a blight study, which is basically you're a municipality that wants to blight an area, you hire somebody to come in and look at the properties and generate a report for you that'll basically justify what you want to do. The smoking gun, I'd say, in that report was either 12 photos of pavement cracks in parking lots, some of which were like not specific to a property. It was just like a photo of a crack in a parking lot that could have been anywhere on planet Earth, and you just have to take their word for it that it's a property in this neighborhood. But there was another photo of a dumpster by a building that had some trash on top of it. And in the Blight study, the author asserted this same trash has been on top of this dumpster for 5 years. Made that assertion. And
5-year-old trash.
5-year-old trash in the same spot. Meanwhile, between the time that he last observed it, there have been 1,000-year storm events in this area, like very serious thunderstorms. And he makes a claim that trash sat in the very same spot for 5 years. But there was no smoking gun in Brentwood. There was not a single serious property condition that the city was able to identify. It was, honestly, peeling paint, cracks in pavement, and then issues with things like fascia or soffits that, like, had you knocked on a property owner's door or a business owner's door and said, hey, like, your paint is bad, you need to fix this, anybody in their right mind would have done it, especially if they had been told, if you don't do this, we're going to blight your property and take it from you.
And there was no smoking gun in Perth Amboy either. Like I said, they really didn't say in the Blight study that anything was wrong with either property. But something common to both Blight studies is the use of zoning changes to automatically qualify as blight. In Perth Amboy, for example, one of the things that they cited as blight is that these two properties are not set back far enough from the road, or that they're too close together. Now, these are all zoning changes that were implemented post the construction of these properties. All that means is that they couldn't be built the same way today, not that it's illegal to have them there now. And I think in Brentwood, it's the same way. The city of Brentwood, probably in preparation for this new development, made a bunch of changes to their zoning in 2019, such that in order to have a restaurant, you need an acre. There were setbacks. You can't back out onto the road, for example. That doesn't mean that the properties that are less than an acre are illegal now. That just means that they can't be built the same way. And in both cases, it's basically like saying we can use zoning to make your property illegal and then take it from you. And that can't be right.
It's almost weaponized zoning in a way.
Yeah. Yeah. And that in conjunction with the blight designation itself, you run into a situation where folks usually have grandfathering rights or non-conforming rights when zoning changes. So if you're a property owner, you're leasing to a restaurateur and they are like, we don't want to keep operating. Usually, even if restaurants are no longer allowed on your property, you have like a year or 2 years to bring somebody in. And as long as you keep using the property for a restaurant, you can just keep using it. Well, when you lose a tenant, your zoning has changed, so now you have a non-conforming use. You're on a clock to restart that use. It's hard to pitch an entrepreneur on a space to invest in when you yourself as a property owner might lose that space via eminent domain. And then, you can't guarantee any lease term because you don't know if you're even going to own the property. And so you have non-conforming uses that expire if they're not resumed. And you have a blight designation that makes it really very difficult to resume the use if it stops. But even with that, in the Brentwood area with 75 properties, I think that the number of vacant storefronts was, you could count them on a handful and, on a single hand. Jeez.
Well, and I still can't get over that the smoking gun in Brentwood, Missouri was really a matter of peeling paint and cracks in sidewalk and apparently mythical 5-year-old trash that survives even the strongest storms. I mean, wouldn't that make practically the entire city blighted? I mean, I can't think of a single town that I've been through in America that hasn't had at least one cracked sidewalk.
Absolutely. I think that the conditions they used would allow the blighting of virtually every property in the country. And I think a good example of this is at trial. The person who wrote the blight study for the city of Brentwood, we presented him with photos of other buildings in the city. Like, there's a really nice shopping center that everybody is very proud of. Mm-hmm. And we showed him some trash around some of the buildings there, cracks in the parking lot, cracks in the pavement, and said, would you be able to find this blighted? And He tussled with us a little bit about the private properties, but we also showed him Brentwood City Hall and the Brentwood Police Department, and I think the Brentwood Middle and High School. And he was more than happy to tell us that if he had ever been hired to inspect those properties, he would have found them blighted. And it was on the basis of things like, oh, there are cracks in this parking lot, and those are like sort of minor conditions, to get back to Kim's point about criteria and sort of like narrowing this discretion. The criteria, chips in paint, cracks in pavement, those are things that are relatively easy for property owners to fix. And when you're going to blight an area, like, there's a permanent consequence, including, being subjected to eminent domain. The property condition should be sort of lasting, significant issues that take more than a day and normal labor to fix. It's got to be something that's really carrying on and really dragging down activity around the property, I think.
So, Bobbi, what's next for the clients in these cases? I know that we just had this trial in Brentwood, and the Perth Amboy case was filed only just a couple weeks ago, so they're kind of in very different stages, I would imagine, but kind of what's next in both of these?
So in Perth Amboy, like you said, we just filed. So the city still hasn't even answered our complaint yet. What the interesting thing about Perth Amboy is that at this point, we are limited to the record before the planning board. So our first order of business is going to be to try to supplement that record, because the planning board meeting, they didn't let the client's blight consultant testify. They didn't really look at his challenging study. So we want a court to look at this meaningfully. The judicial review provisions in both New Jersey and Missouri have to make it so that these reviews aren't just rubber stamps of the blight designation. So we want a court to actually engage with the facts here and see that there's no blight. So that's the hope for Perth Amboy. In Brentwood, like you said, we just finished the trial, and kind of similarly, the judge has more evidence in front of her, but we're hoping that she'll actually engage with the statute and the legislative changes post-Kelo and the intent of the Missouri legislature in curbing some of this eminent domain abuse.
And I mean, Bobbi's right to hit on the sort of factual nature of the review. I think folks who are familiar with IJ probably hear a lot about rational basis review and, judicial disengagement. In Brentwood, our judge took, the parties asked her to, she didn't take it on her own volition, but she took a property visit and she walked around the 75 properties to see what they look like today. And we presented a considerable amount of evidence. We had a week-long trial the first week of May. A lot of photos of the area, some videos of the area, a lot of testimony from our clients about like the things you would expect to see in a blighted area just not being present. I think our clients, Amy and Carolyn, were like, I've been working here for 20 years and I've never felt unsafe. I've never noticed any issues with crime. Those kinds of that kind of testimony, those kinds of documentary evidence like photos and video. A lot of IJ cases where you don't really get to introduce that kind of stuff, but it, I think, has been very important for us in Brentwood.
And these families have a lot riding on these cases. I mean, you talked about, I think at one point, a multi-generational family business for our clients in Perth Amboy. I mean, these are people who immigrated to the United States kind of in search of the American dream. What was their reaction when they found out that IJ wanted to get involved and help them out?
Our clients in Perth Amboy had legal representation and media attention before IJ came onto the scene. They are exactly what you would think an IJ client would be. They're very comfortable sharing their story, and they're passionate about protecting their property rights. And they were kind of trying to do this on their own with the help of local counsel. When IJ came onto the scene, I think they were happy that, we were able to help them amplify their message and kind of say all the things that they were saying, but a little bit louder and to a broader audience, and with the full force of IJ's eminent domain history behind it.
Yeah, I think that our clients felt relieved that they had stood up for themselves and appeared at public meetings and tried to say, like, we don't want to have to go anywhere and all of this. But I think when clients sign up with IJ, we have a long intake process, but we deploy a lot of resources to get a case up and running, and it inspires a lot of belief in our clients when they see that, the wheels start to move and all of our colleagues in our different departments show up. When you're a small business owner and you feel like you're up against a $500 million development and you see some folks who are like, no, we'll come meet you. We'll come around, take some photos. We're going to go see you. You're going to meet these people. They really start to believe that they're going to get to punch the bully back. And
it's got to feel good.
It's really fun. Yeah, it's really fun.
Yeah, I mean, I'm glad you brought that up because it strikes me that these cases must be extremely resource intensive. I mean, every IJ case is resource intensive, but these involve sort of, amassing such an astounding amount of evidence, of kind of re-studying every single one of these properties and whatever, and going through a week-long trial. Like, that's an extraordinary amount of resources. And it seems like things that people wouldn't be able to afford to do themselves, right? Like, no kind of normal person would be able to foot the bill for private attorneys to litigate these cases the way that I imagine you guys are. So can you talk about that a little bit?
Our hours for the first 5 years of the month probably speak to that. It'd be very difficult for a single property owner or even a small group of them paying a lawyer to carry out this fight. I don't know what the situation is under the New Jersey statute, but in Missouri, you're often under a significant time crunch to get this issue litigated. There's a 30-day provision in the statute that allows either the property owner or the government to take the case to trial within 30 days. 30
days of what? Of the Blight designation vote?
I think the statute is a little bit unclear, but it's either from the initiation of a condemnation action when the city's already made its blight determination and they're coming to take the property, or after they make the blight determination, if you're a property owner, you can sue and say, hey, court, this is not an okay blight determination. But the city can say, okay, that's fine. You have 30 days to get your evidence to show it. And
that's crazy, because normally that's we go to discovery for 6 months, a year, 3 years in some cases.
In Brentwood, for real, we were in discovery for over a year, I think.
Yeah.
And I mean, just in the first 5 months of this year getting ready for the trial, we also had to brief summary judgment and resolve a number of outstanding discovery disputes that were, it's litigation. Naturally, you're going to be fighting to get stuff the other side doesn't want to give you. But this is a question of the city's blight determination. And so many things, many very important things are uniquely in the possession of the city.
Sure.
And so you have to fight really hard to get all of that. Doing it as a paid lawyer on your own, I think, is a monumental task. And sometimes the case law in these areas can reflect that. It's not the most cogent analysis in some of the cases because it's often, you're creating the best record that you can for your one property owner client, and you can't litigate to the ends of the earth for that. So we are, it's really valuable to have IJ on the scene trying to right the legal wrongs, I think.
Well, and in Perth Amboy, I don't know that the clients would have challenged. They did go to the city meetings. They did speak on their behalf. They had an attorney speak on their behalf. They even retained their own blight consultant who did a competing study.
Wow.
But I don't know that they would have continued on for judicial review had IJ not stepped in, just because of, like Bob was saying, the resources involved, the expertise needed, and just the familiarity with the statutes and case law. And in New Jersey specifically, IJ's got a great track record fighting eminent domain abuse. And I think that it's great that we're involved in Perth Amboy, so we can hopefully add to that.
Awesome. Well, thank you so much, guys, for coming in and talking with us today.
Thanks for having us.
Yes, thank you. You're welcome.
And thanks to all of you for watching. If you'd like to get more of our videos, you can like or subscribe to our channel. And if you'd like to support this case and our other work, you can join us with just $5 a month at ij.org/monthly. Thanks so much.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.